And Your Honor, I want to bring to your attention a decision by Justice Abureli, Collins Otieno Nyango versus Republic in criminal petition number E002 of 2023, where the court invites. But I just wanted to bring it to your attention because I've just been notified of it, and it's very relevant. Violation of rights of a pattern that is brought before the court. Unless the court ever needs to say it, I'll sit down.
No, it's not that I don't want you to say it, but I was already, I've started that I didn't know that you are still receiving.
No, it's a decision of the court. I mean, it's the duty of my advocate, if I'm aware of a decision that is relevant to what is happening, to notify the court. But if the court doesn't want to hear it, I can sit down.
So you said it is?
Collins Otieno Nyango versus Republic. Criminal petition number E002 of 2023 by the Honorable Justice Abureli. Collins Otieno Nyango versus Republic. Of import in that court, Your Honor, is that if there is a violation of a right, then it is criminal petition number E002 of 2023. The court was saying in this case, and the facts sit almost squarely with this one, on the question of custodial violation of rights by holding a person longer than the prescribed period. That if there was a violation of rights, even to register a charge will not be permissible. And in this case, we are telling the court, if you count 7 days from today, from yesterday, then there's an admission by the state that there has been an illegal detention for 6 days. And in light of that illegal detention for 6 days, this court is duty bound to release them. I'm still talking. Please, I'm still talking. No, please, I'm still talking. I'm explaining this decision. Please. No, please, just allow me to finish. You'll have your time. You'll have your time, please. You'll have your time. Please, sit down. These are decisions of the High Court speaking about violation of rights. And the court even proceeds to say you cannot even now register the charge. In this particular instance, they have been given 7 days. What happens to the violation of rights in the previous 6 days they've been holding it? Unless this court can only cure it by saying, we will take that into account when computing the days. But if we don't, and the court is now aware of violation of rights, then these proceedings must end at this particular point. Because what you have are persons whose rights have been violated by the state and they desire to continue violating those rights. And the court cannot be used to perpetuate that violation of the rights of the individuals before it.
Your Honor, I also wanted to seek clarity at what stage we are in these proceedings, because from what I understand, the criminal procedure is very clear that when you've made a ruling, especially on the same ruling that you are asked to review, you made a final order and you clarified and you even went further and read. Now during the clarification, Your Honor, you've gone ahead and stated that you're now giving directions. I'm struggling to understand that from where we stand, where do we respond? Are we still, at which stage are we in these proceedings? Because from what I understand, we come for a review of a ruling that has been made final. It has also been made clear that if you are dissatisfied, the best procedure is to appeal. Counsel has gone ahead in the course of you writing your direction. He is still making more arguments. He's gone ahead to mention an authority, which you also need to look at. So I think it would be good to mention that we are not in the right direction as you speak. And the best thing to do is for counsel to package his arguments in an appeal court. I think I needed to mention and correct that, because if we keep on making arguments, I think we'll also come for another ruling tomorrow.
I mean, our court is allowed, our court is allowed to interpret its directions and rulings. We are seeking interpretation in light of the facts. The ruling has been made. I have not even applied for the court to review. I have simply said, the decision has been made. We are back to the ruling of yesterday. We are seeking interpretation in light of the facts which are there. So 7 days, we are not disputing the 7 days. We are simply saying, of the 7 days, you held them for 6. Let's get directions.
That is a court of law and order.
So there's what we call interpreting a ruling. Interpreting a ruling is allowed. Interpreting a judgment is allowed. So we're asking the court to interpret its directions based on the facts and the decision that has been made. That's allowed. If you are not aware, I'll let you know.
Your Honor, with your kind permission, I wish to wholly associate my submissions with my learned colleague, Mr. Sonia. Your Honor, it seems that there has been a breakdown on even how parties should address the court, because Mr. Willis Otieno was making a rejoinder to my submissions, and he introduced new issues: infringement of constitutional rights, of the rights of an arrested person, and we are at a loss as to how to proceed with regards to the new issues which have been raised, which also raise constitutional issues outside Article 25A and 25B, which this court is not clothed with the jurisdiction to entertain. Your Honor, you note that the authority which has been presented before you is an authority from the High Court, which has jurisdiction to deal with infringement of rights of an arrested person.
So the point is that he needed a clarification or an interpretation by the court on the base, and he has cited an authority and they made a few submissions. So I give you time. I want you to respond to what you are saying. Just that then the court will give direction. So the issue is the interpretation of the base. When do the base?
Your Honor, the state had approached this court under Section 36A of the CPC, seeking an extension of the 24 hours beyond which the respondents should be held, and we had sought for 14 days.